let's start with FIRPTA. Anybody know what FIRPTA stands for? Right, okay. Foreign Investment in Real Property Tax Act. Okay, and it's been in existence for quite some time. The purpose obviously is to collect withholding from foreign persons that own real estate in the United States. So it's a foreign person under the FIRPTA, and that description includes non-resident alien individuals, foreign corporations, foreign partnerships, foreign trusts, or foreign estates. So a foreign person is a non-resident alien who is neither a U.S. citizen nor a green card holder and who does not meet the IRS prescribed substantial presence test. So there is a presence test, but even with the presence test, that's not enough. You have to, they are required to have a tax identification number that is specific for the United States. So there are various requirements in order to bypass the FIRPTA requirements. All right. And the next question is how to avoid FIRPTA. You don't actually avoid it, but there are situations where it doesn't apply. So the first one is a seller's affidavit or certification. And this is when a seller can say, I am not treated as a foreign person, and they have certain things that they've met, they've gotten their certification, or they've gotten their Social Security or a TIN number that qualifies, and so they'll sign a certification that says that. So long as the buyer has no actual knowledge that the seller is making a false statement regarding his or her status, and the buyer has not received any notice to the contrary, the buyer can rely on that FIRPTA affidavit. But it's better to make sure ahead of time. You don't want to wait to the day of closing, because the buyer is the one that will be responsible. That'll be one of the other questions, who's responsible, and it is the buyer that's responsible to do the withholding and report. So we can get to that. The second way to avoid FIRPTA withholding is the buyer's affidavit. And the affidavit can be executed only by an eligible buyer, and I'm going to talk about that a little bit more in just a minute or two as well. Then the withholding certificate may allow a lesser amount withheld at closing. Sometimes the seller's selling at a loss. You'd think, oh, well, we don't have to do a withholding. That's not the case. You still have to do a withholding. So if the seller prepares ahead of time, they can fill in an application for withholding certificate, and that will allow them to protect themselves when it comes time to the closing table and not have to have that withholding. So the first FIRPTA exemptions, this is with the buyer's affidavit. And the requirements for that is the sales price has to be $300,000 or less. That's the first requirement. I'm on the top of page 2. Well, no, mine doesn't match yours because I have the answers in mine.
Halfway down in page.
Okay, thanks. All right, so the second requirement, the buyer signs the affidavit at or before closing stating that they intend to use the property as personal residence for at least 50% of the time the property is occupied for each of the next 2 years, for 24 months.
So use as their primary residence?
Not, they intend to use it for 50% of the time. So if it's only used 1 month out of a year, and that is the buyer that's going to use it, they're not going to rent it out, that qualifies. It doesn't have to be 180 days. It has to be 50% of the time it's in use. And that the buyer can say that that's what they're going to do. They're not going to be renting it to any other people, or if somebody else is going to be using it, it's going to be less than their use. then they can go ahead and sign that affidavit, and it's not necessary to do the withholding. Why that would qualify as a break, I don't know, but it does. So, the tax people long ago made that ruling, and that is the ruling. The next question is, who is responsible for FIRPTA withholding? Who's been listening?
The buyer.
The buyer, okay. That responsibility is on the buyer, and it used to be 10% of the purchase price is what was withheld. It was upped in 2015 to 15%. So that can be a significant chunk. So that's why it's important for sellers to prepare ahead of time if they know this is going to apply to them. And you can help them prepare if you know you're dealing with a Canadian or someone who's clearly a foreigner. You can let them know you need to start the process ahead of time in order to get your exemption, or be not too surprised that this is going to happen. Can the buyer assign the responsibility for withholding to the settlement or escrow agent? What do you think? No, they cannot. Very often, the settlement agent will agree to take on that responsibility. I know my office does. I know other title companies that will not. So it just depends. But the buyer technically does not have the ability to assign it, and the buyer is ultimately responsible. Can a buyer become liable for unpaid taxes by a foreign seller? And yes, they can. If they don't do the proper withholding, the land itself becomes security for the lien, for the withholding lien. So you want to make sure it's all handled clearly. Sellers may be unhappy, a foreign seller may be unhappy that it has to be done, but to protect the buyer, it has to be done, and it has to be done at the time of closing, because the turnaround time, that money has to go to IRS within 20 days with the proper forms. Are tax ID numbers required for all parties? And yes, they are. In order for a buyer to even sign one of those exemption affidavits, when they qualify for that, they have to have Social Security numbers. So it can't be a foreign buyer. And the seller has to have those TIN numbers in order to be able to sign a seller's certificate affidavit, or they'll do the withholding certificate, which may reduce their withholding. All right, the calculations, see, I knew this would move the thanks. The calculations, I have in your handouts a flow sheet that shows you a breakdown. So this is actually something that Kim advised me is another law firm that they've used before for this class. So I pulled it and was able to use this. The seller, if the seller is a foreign person and the buyer is acquiring the U.S. real property interest, then you either no, they don't require compliance, or yes, they do. If they're required, then you go through the process of determining, is it going to be the buyer's residence, or are they going to be the only ones using it during the next 2 12-month periods. And then you determine, okay, is the total purchase price less than $300,000, then there's zero withholding. If it's more than $300,000 but up to $1 million, it's a 10% withholding level. And anything over $1 million, it's 15%. All right? So that is how it breaks out for the purpose of withholding for the calculations. Now, the actual documents that I have included in your handout. First, you have that flow chart. Then you have the seller's affidavit or seller's certification. So this is a form that's available. I don't know if this is available with the FARBAR documents. The buyer's affidavit is, and that's the next one. It is part of the FARBAR forms, so you can always get that if you need it, if your buyer qualifies. But the seller certification, if they qualify, that's the affidavit there. Then the buyer's affidavit. Then the application that would be filed is Form 8288B for IRS form. And it takes them 90 days usually to process this. So that's why I say if you have a foreign seller that you work with, you want to make sure that they, if they're going to apply for certification, that they do it early. Yes?
Now, is an accountant going to fill this out or a lawyer?
Yeah. That is one of the questions I get to,
Okay.
but you guys just need the basic information. You should never start to try and fill out any of these forms. It's either an accountant or an attorney that's normally an attorney that specializes in tax items that would be filling out the form. Okay, so you just want to make your seller informed. You don't want to do that work for them. And then the final item there is the actual FIRPTA addendum or rider that goes with the contract. When you know that you're dealing with a seller, foreign seller, or even if a buyer, you're representing a buyer and they're making an offer and they realize that it's a foreign entity, a Canadian or other corporation that owns the business, foreign corporation, then that form should be attached to your contract.
And should that be listed in the MLS so we know that?
That would be helpful. I don't know if that's a requirement, but that's a very good point. And the basic, where that would come up, of course, is as a listing agent. The listing agent would have that information. Do you know the answer to that, Kim?
I do not. Whenever y'all are ready to eat, if y'all want to take a break, whenever you're ready.
They can go ahead. This is a good time because I'm about to go into common situations, questions, and answers. So they can certainly take a break and get their food.
Right over here, I'm going to print a couple of handouts, I think. Amy, you need one, right? Anybody else need a handout but didn't get one? Okay, so I'll print 2 more copies of it.
That's the withholding certificate. It's mentioned. But it's this item, the withholding certificate. Right. It's what they, the form they would apply ahead of time. They qualify, they're a non-resident alien. They're not a U.S. citizen, they're not a green card holder. And they do not meet, there's a prescribed substantial presence test. But even if somebody's been in the States for the required amount of time, they still have to have the TIS, which would allow them then to probably do the self. So that's a calculation you don't need to be responsible for. You just need to tell them.
No, that's different though, because my team,
for that.
whenever I'm on a team, I'm
Yeah.
so-
I do have the breakdown for that, but it was not something that I thought you guys needed to have that. Exactly. Yeah, the non-resident alien corporation, partnership, trust, foreign estate. And the foreign estate would apply probably if someone owned the property, if the property was their estate, so foreign entity.
But I do all of our
Yeah, okay. Nice to meet you.
You know what? I see what you do.
very, that's what I used to do. I was a VP of well, not really, not really. No, hard for not.
I'm sure so. I'll do it again.
You should do it right now, since you're all taking breaks.
Then I'm eating the food in my mouth.
I think that's the girl, she was like far away, right? Yeah, she's not coming back now. I think, no, maybe it wasn't her. It was somebody that lives in Utah. Yeah, she's a oh, yeah, I'll have to look into this. We were supposed to be in there at long.
I can pull off them shorts. Like you sure?
Yes, and I'm sure there's a lot of, yeah.
In the sun, you come through. No, I'm good.
So like the people that wanted to answer, we can give something. I hope they don't have everything, like I don't want to honor the 13 counts. This is good, good game. I'll do mine. Yeah, he needs this.
No, I already got it.
Is that right? You didn't take a picture of it?
I know you took a
What is
picture.
wrong with you?
I'll take a picture.
Right, all right, yeah, take a picture.
I want you to look like your dad. Where's your face? Matt, we're gonna use this.
Bad.
It's okay.
I'll just share what you did. Yours looks sharper than mine. It's like some text.
The good thing, man, you know, inside, it gets so like, when you start playing, it's so small, so. So I'm gonna
So do you? Oh, that's good.
So this was your doing? As far as what we got for lunch? That
No,
was-
that's Kim's.
Well, I was gonna thank you, because it's the best lunch I've had here for a while.
Yeah, this is awesome. This
Kim
is
does a
awesome.
great job.
Yeah, they're complimented.
Oh, good. So then the printer messed up. It printed one and then it stopped, so I'm gonna have the other copy printed.
Nailing it, right?
Ooh, this Friday.
No, she don't like the finite small setting. Like she has to do this, she has to point her toe to get the camera. It looks
them back to their tables? Almost ready? Do y'all have, I don't have the printout that tells me what the time frame was. It was running from 11:30 to 12:30?
One o'clock.
To 1, okay, all right, so we have additional time, so that's good. Okay, so some common questions, I'm going to go to those now. There are an infinite what-if situations, so it's always important to just be aware. I'm going to give you some of the common situations and common mistakes, but I will say that a prudent broker and realtor will always have a list of CPAs or attorneys that they can refer their clients to. That would be the recommendation, so that, because you're not to do the work, you're not to give them advice, but you can steer them to the right direction. All right? So sometimes the question comes up, is a single member LLC, would you require FIRPTA withholding for a single member LLC? And the answer is yes, it could if it's a foreign entity. If the single member is a foreign person, then yes, that qualifies and they are required to comply with the FIRPTA. Okay, how about you have a husband and wife, they jointly own the property, one is a U.S. citizen and the other is not. Can they allocate the price 100% to the U.S. citizen? What do you think? No, they can't. So again, the non-U.S. citizen, the foreign person, will have to handle withholding on their portion of ownership. Can a foreign buyer avoid withholding by assigning the contract to a U.S. citizen entity? So now you're talking about the buyer, whether it's a buyer or seller. Can they assign it to a U.S. entity? Let's start with the seller first. So seller is a foreign entity, but decides that they have a contract for $100,000, but they can assign it to a U.S. entity for $120,000. Will that avoid the FIRPTA?
It's under 300, so it would be avoided anyway.
No,
No?
not necessarily. Not if the buyer has to be able to live there, or be the occupant for the 50% of the time for the 2 years. But all right, so I'll jump beyond 300,000, go to 500,000, and then they can turn around and sell it or assign it to a U.S. entity for 550,000. Have they avoided the withholding? And the answer is no. They have a 50,000 gain that would be responsible for FIRPTA withholding. And the same thing applies on the buyer's side. The buyer can be a foreign entity. That's not really going to be the issue. It's whether or not the seller is a foreign entity. So the buyer assigning it to a U.S. entity doesn't change the circumstance of the seller's status. So they still have to do make sure that the FIRPTA is complied with. Okay. If the buyer buys the property intending to live in the premises as a residence for 2 years, but fails to do so, what action is required by the buyer? Have they lost the exemption? And yes, they have. It's very, it's a tricky thing, because if a buyer is willing to sign that affidavit, they're basically saying, to the IRS, you don't need to do this withholding because I'm going to live here for or be the primary resident for 2 years. and then they decide, circumstances. It may not be a voluntary decision. It may be circumstances that push them into not being able to be there for 50% of the time of the 2 years.
What if
So-
it's vacant land?
Sorry?
What if it's vacant land? Does that change anything?
Obviously, they're not going to be residing there.
Right.
So it would not qualify for that buyer's affidavit. The seller is foreign but has a social security number. Are we good not to withhold?
No.
Not necessarily. You don't get to make that decision whether or not they have the status of a foreign entity. So even if they have a TIN or social security number, you need to just do a little bit more investigation, just make sure that they qualify, either can do the seller's certification, which if they can do that, they can put a social security number on there so everything appears to be fine, then the buyer's pretty comfortable. They don't have knowledge that's contrary to that certification. So then the buyer can rely on that and doesn't have to do the withholding. But it's not just the fact that they have the social security number. And I mentioned this earlier, the seller is taking a loss on their home. They don't need to pay FIRPTA withholding, right? Wrong. Okay, because even though they're taking a loss, the law does not provide an exemption for that situation. They still have to go through the process of the withholding, and then they have to apply to get the money back, showing that they did not have a gain. And that's time consuming. That means your seller's without their money for a whole time of process. So the best thing to do is get their withholding certificate early. If they know that's the circumstance, they can, that it's going to take them 90 days to get it. They get it before they sell the property, then they don't have to do the withholding, or they have a limited withholding based on whatever they're qualified for their certificate. A foreign seller doesn't have a TIN and is willing to pay the IRS. Can the money just be sent to the IRS without a TIN? No. They have to be able to track it, so there's a process and an application that has to be done in order for them to get their appropriate identification and to have the appropriate filing. So again, this is something buyers aren't going to want to handle. So they need to make sure that a CPA is involved to handle it for them. And generally they're going to want that to be a seller cost, of course, because it's the seller's responsibility, because they're the foreign entity, even though the liability is on the buyer. So these are things you need to know ahead of time just to prep your customers, your clients. The property is under $300,000 and the buyer is going to live in it. Doesn't that automatically exempt it from withholding? They have to sign the affidavit, and the affidavit requires certain information, social security numbers, all of the appropriate information. So it's not just, okay, you meet the qualifications, so we're clear we don't have to do any withholding at time of closing. There should always be some affidavit or withholding in a closing that involves a foreign seller.
But not a foreign buyer.
Yeah, foreign buyer doesn't matter. It's going to be an issue for them when they go to sell the property. Yeah. Is a transaction from a foreign seller to a foreign buyer exempt from withholding? And no. Okay. Again, it's an issue of the seller is foreign. They have to comply with the FIRPTA in one way or another. Okay, the FIRPTA withholding was paid at close of escrow, but not that much money was due to the IRS. How does the seller get their money back? And at that point, there's a specific application that they have to apply. They can either get in advance the withholding certificate, which is in your packet of documents, or they have to apply afterwards, and that takes longer. It's 90 days to get the certification. It's usually about 120 days to get the money back. So better to be prepared ahead of time than to have to do it at the time of after closing. The seller lives in another country but says they are a U.S. citizen. Is withholding required?
Yeah.
Ye-
Yes, no?
Yes, no?
No, not if they're US citizens.
Right, you have to get the verification. They well may be a U.S. citizen and, then there's no withholding issue. But if they're living in a foreign country, then you want to clarify, what are the circumstances. So that's again, a situation where you have to have more details to determine. Should a foreign buyer be concerned about FIRPTA? And this just kind of goes to the question you were asking about a foreign buyer. Yes, because when they turn around and want to sell the property, it's going to impact them. So they do want to be aware of these rules. And as you representing a customer, whether they're a buyer or seller, you can have that little bit of information to say, you want to check with your accountant or a tax attorney to make sure that you're, not going to have issues and not going to lose part of your money from the sale of the property. So the sellers and buyer don't want to pay a CPA to answer their questions. Can the real estate person or escrow person help with FIRPTA questions?
No.
No. Not unless they're an attorney. An attorney can answer some of the questions, but a normal title company will not, should not, and obviously the real estate agent should not. You don't want to be caught in that bind. So those are the basics on FIRPTA. Any questions? Okay. We did pretty good on timing on that. So now we're going to go to 1031 exchanges. Everybody know what a 1031 exchange is? Okay. So 1031 exchange, it's often called that, is a like-kind exchange. It does not make the tax go away. It defers the tax to another day. So, and there's some very nice advantages to that, which I'll discuss as we go through this little list. It's very specific. There are specific rules for it, and the rules may be changing. And the rules may change with every administration that comes in. That's always a possibility. So, it's an exchange for, all right, there's two, well, let me give you the brief description that was written down here because I just did that one off the top of my head. Exchange of properties that allow for taxpayers to exchange property that is similar and defer the recognition of gain to a later date. So, and that can be on retirement or death. Retirement being that you have less income coming in, so your gain at that point may get taxed at a lower rate, so that's beneficial. Or upon death, it may not get taxed at all. So it's the asset appreciation that you're deferring on. The two requirements for regarding the property are: one, it has to be productive use in trade or business or for investment. So the bottom line, it has to be business or investment property. It can be vacant, but it has to be held for business or investment purposes. The like kind, in the eyes of the IRS, they use a pretty liberal definition for like kind. So you can exchange an apartment building for a farm, or vice versa. Sell a farm, buy an apartment building. You can sell small apartments or small houses that you rent and buy a big apartment building with that money. Or sell a big one and buy little ones. So there's different ways to use this to your advantage, to the taxpayer's advantage in order to maximize holding and deferring their gain, or deferring the tax on their gain. Now, it used to be, let me read this first and then I'll come back. Property that cannot be exchanged under a 1031 arrangement includes stocks, have never been allowed, bonds, notes, and partial interests in partnerships. It used to be that a business, ongoing businesses could exchange for a like-kind ongoing business, and the personal assets the equipment would be included for that deferral. That has gone away. That is no longer allowed. The tax rules that came into being a couple years back, you can no longer do any personal property exchange. It's strictly real estate. Okay. The key requirements regarding the process: you identify replacement property within 45 days from closing. So if you have a customer that's getting ready, and it's a nice thing for real estate agents because you're going to hopefully get 2 sales involved with one. So you have somebody that's looking to sell one and buy something else. You need to be aware that they've got a limited time frame to identify that replacement. So we call them relinquished property and replacement property. So obviously they own the relinquished one and they're getting ready to sell that, but they're going to reinvest the money in the replacement. So they start looking for that replacement property because you want to be able to close the relinquished and then identify the replacement within 45 days and close on it within 180 days. When you're dealing with that situation, if you have possible, you can have more than one replacement property that you identify. You don't have to just stick with one. You can identify several. There are some limitations, so the customer should speak with an attorney or an accountant to identify limitations because there's a percentage you can't exceed. But yeah, you can sell one property and buy 3. So as long as you're reinvesting that money from the sale of your relinquished property into replacement properties and you meet the rules, then you're fine.
But it doesn't have to be done before you close on the relinquished property, right?
No. No.
After 45 days out.
You have 45 days to identify property. So if you haven't yet found something, you still have 45 days, but you cannot go one day past that 45-day time period. It is very strictly enforced. Not that they know, but.
Okay, just to make sure I understood. Okay, I'm listing the property and we sold it, but now we're going to go to closing and actually do the exchange. So it's 45 days from when they actually sell and close the property?
Correct.
Okay, and then the 180 days is?
The time that they close on the replacement property.
Okay, so the closing is the 180 days they have to close on it.
Right, right. So
Okay, and how do they, when you say identify, are they doing this at time of closing? Are they identifying the properties then?
no, they have 45 days to identify. What I do and what most 1031 agencies will do is provide a form that they can fill in, and it shows the deadline date. This is your deadline date.
Okay.
And they fill that in and say, I'm going to, I'm identifying this property, and you can identify it by street address. You don't have to identify it by a big legal description, but street address. And then if that one starts to fall through and you're still within the 45 days, you send another page and say, okay, I'm identifying this property.
Are we sending it to you?
You send it to the qualified
attorney?
intermediary or
Or
the
whoever.
attorney, whoever's handling that process. Yes.
Okay, and they usually have a form for that?
Yes, they will have the form for that.
And then I'm assuming in our MLS forms, there's a form when we actually sell their property that they're going to do a exchange?
There is, yes, and that's one of the, that's attached to your outline is the rider for 1031 exchange.
Okay, and afterwards we identify the person that's doing the exchange, we should know that ahead?
You don't know it ahead of time. If you're working with a seller that's doing that, they need to pick out somebody. It can be, there are multiple 1031 companies. I was saying to somebody earlier, First American Title has a company that they use. Stewart Title has a company that they use. I do it through my company, Oceanside Title. As an attorney, I prepare the document, and the charges come from me for the preparation, and then there's just a small handling fee for the monies that are held. One of the important things is that the monies cannot go to the seller. I had a client that was talking to me about doing a 1031. They closed. We wired them their funds. He called me a week later and he said, I think I want to do a 1031. I said, it's too late. You got the monies.
Oh, wow.
And I had told him that up front. He just, hadn't changed his mind.
May I ask the range of what it costs for the person that's going to do that? Like, is it 300 to 500, or is it 1,000?
Yeah, it's a range. My total fees are $550. It's $450 for the document preparation and $100 for the handling
Okay.
for the title company, and then wire fees. I've seen other companies where it's $1,000. I've seen companies where they charge both for the relinquished property and the replacement. They charge a fee, and sometimes it might be $250 on one end and $250 on the other end. So, you know, it varies.
Thank you. I just kind of want to get an idea.
Yeah, that's the range that I've seen. I don't know if others have had experience with companies that have different, but that's usually the range. Now, you can get into a situation, it's not on this list, where we have a reverse exchange. So let me come back to that after we finish the outline, and then, you know, I'll be glad to talk about that a little bit. Yes?
So they filled the form out, they've identified the property, excuse me. They're right at the end of the 45 days, but they didn't get it under contract. So does it stop counting, like, they've lost out then, right, if they didn't
No,
get it?
no, the
Okay.
contract could come a week later.
Okay, so as long as they've got it identified on the form.
Right.
Money just stays with the title company like an escrow,
Okay.
right? The money just stays with the
Right, the
title
money
company.
stays with the qualified intermediary. But yeah, you know, they can still be in contract negotiations past the 45 days.
Okay.
But they have to have at least gotten that notification to their QI within that 45-day time period. And if the 45 days falls on a Sunday, you don't get to roll it to the next day. It's very crucial. There's case law on that.
So we have to count every day, not, they don't disregard Saturday and Sunday.
Right, they do not. Yeah. Yeah. Okay. So that was number one for the process. Number two for the process was the close on the replacement property within the 180 days. And usually that's a little bit easier unless something suddenly goes wrong with title and you have issues. Then you have to find, you know, a way to get it done. All right. The key requirements to protect the exchange. You want to have your documentation in order. So first of that is the clause in the contract. So that's your addendum or your rider that covers for the contract. That's available with your contracts, with the Florida Bar contracts. It is possible. The rules allow you to do the documents 5 days after closing. That's okay. But it's easier to do them, obviously, before or at the time of closing. And the second part of that is that the funds are held by that qualified intermediary. They cannot be they cannot be wired or delivered to the seller. That cuts, at that point, you no longer have a 1031 deferred exchange. So as long as, you know, if somebody's not sure, you know, what I say to them is set it up, have the money held. 5 days later, if you change your mind and you want your money, just, you know, email the qualified intermediary, say I'm not doing this as a 1031, please give me my money. And that's all it takes.
Title company can hold the earnest money check, though, right, when you write the contract?
The earnest money? Yes.
Yeah.
Yes.
So you're just talking about the closing, total closing.
Correct. Correct. It has to be a qualified intermediary. Not all title companies will serve as a qualified intermediary. What happens if the title company has the escrow, the earnest money deposit, then they'll just send that along for closing as normal.
If they choose to use a different title company, but they want to use you, are you able to do that as well?
Yes, I've done that often, you know, where, you know, the title company closes. You know, I still have contacts in South Florida, which is where I moved up from. So they do the closing down there. They wire the funds to Oceanside Title as the qualified intermediary, and we set up the account to hold the funds until the replacement property closes. And we don't have to close on, you know, it can be another title company that's doing that, and we wire the money to that company. So we like to have the business, but we don't always get those.
Yeah, I'm just asking the question because
Right.
the buyer or seller thinks something.
Okay. So those are the requirements to protect the exchange, and then you have the rider that's attached. Just very briefly, let me touch on the reverse exchange. So it is it sometimes occurs that a buyer or a seller sees a property that they want, but they haven't sold their property yet. And in order to get the other property, they're able to, figure out how to get funds, or they have funds, but they plan to still sell the one and put it in that. They can do a reverse exchange. And it's more involved. The fees are higher. Those fees I've seen range from $1,500 and up, depending on how complex it gets, because they have to make sure there's a tax return done. The way it's set up is an LLC is set up to receive the property. Okay, so the LLC on behalf of the seller goes and buys the replacement property. So now the LLC holds that title. And when it comes time that the seller is selling their relinquished property, they're going to get title from the LLC. But to do that, you have to set up the LLC. The LLC is going to have a tax return that has to be done. So you have to make sure that there's money held aside to do that tax return to protect them. It's basically a wash for the LLC because they're buying it, selling it, they gain nothing. Okay? So it's just all a matter of paperwork and process. So it's a little bit messier, but it still works just the same. Mm-hmm.
Is there a time period, okay, they purchased this property in the LLC, and now they're gonna get their home on the market, maybe it doesn't sell right away, maybe it doesn't sell for 3 months, so it's probably unlikely, but is there a time, is it within 6 months or a year that they can do this, or what's the time that they could do that?
On a reverse exchange, I don't believe that there's a time frame because the LLC holds the property. What's happening here is that they're not going to make any gain.
Okay,
so they don't have to worry about deferring it.
LLC when they sell their property.
Sorry?
Okay, so it doesn't really matter because they're going to identify that property when they sell their
Right.
property, and the LLC could be them or some other people or whatever, so they're just putting the address in.
Yeah,
They
what
do that one.
the reason it's done usually through a qualified intermediary or through a company, one of the 1031 specialty companies, is because you want to make sure that the LLC doesn't run off with the money or the property,
Right.
because the seller is going to fund that transfer. And so now you have strangers holding your property.
Right.
All right. There are rules that allow related entities to hold property. There are specific rules. If you have a relinquished property, you're selling. Your seller is going to sell a property and buy a property from their brother. Okay. Related issues. There are specific rules that allow that, or from a spouse, or from a related company. They might have a corporation they're buying from. That is all permitted, but there's rules that apply. They have to hold it for 2 years before it can then be sold or rolled again. Okay? So all good tools to use and good for you to know about. Your role, again, is to be able to refer them to a company, a CPA or a lawyer that's going to help them do what they want to accomplish. Okay, but by you being aware of it, you can suggest these things to your customer because it's a plus for them to be able to defer if that's what they're planning to do anyway, if they're just going to reinvest their property, as opposed to getting hit with a major tax liability. Couple of the things, and I wrote these out here because I'm going to expand on them a little bit, but didn't want you to have to write the added tidbits, so I did put them on your list. Unlimited use, and I forgot to close that parentheses. But provided you are not, the seller is not falling under a category of a dealer. In other words, you have multiple lots that they buy and then roll and roll. They could become and be considered a dealer under IRS rules. So provided they don't do too much of it, they could have maybe 6 lots. Back in the day when Compass Lakes lots were really rolling, I was doing quite a lot of these for customers. where they'd be buying it for 5 and selling it for 20 or whatever they were able to get at the time. And, they would just roll. Then they would go from there and they would roll it into something else. So you can roll as often as you want. And the plus on that, or the plus, going forward, for the purpose of a 1031 exchange is eventually, if you die owning the property, have never paid the capital gains taxes on it, your heirs get a stepped up basis. At least that's the way their laws are right now. So they get the value of the property at the time of your death. So you may have bought it at $10,000, it's now worth $100,000 when you die. That's $90,000 gain, arguably. And your heir gets the stepped up basis of $100,000, so they turn around the next day and sell it for $100,000. They have no taxable event. It's not their gain. So that's how you defer. You just keep deferring and rolling. And that's the current law. All right? That could change. It can apply to personal residence in specific circumstances. The only time that applies is if it actually becomes investment property. So you've been living in a house, you decided to buy a new house, so then you turn your personal residence into investment property. And then when it meets the, there's a time frame, 2 years out of 5, it's got to meet that qualification. And when it meets the qualification, then you can go ahead and roll that. You can sell it and roll it into a 1031, some other property. One of the other things that's tricky about 1031s is that you are supposed to reinvest the price, not just the gain, but the price of the sold property into new property. People always think, well, it's only the gain. The rule really is beyond that. But the way, you can trigger it with, okay, I get mortgages on it and I pay off mortgages, I get my cash out and then I put a mortgage on the new property. That's all gets involved with the tax accountant and the attorney to make sure that, you're getting the best benefit. And not everybody wants to take 100% of the money out. I've had deals, 400 million deals where they only wanted 100 million out. They were going to take the hit on the rest, pay the tax liability on the rest of it. Yes?
Did you say it had to become investment property for 2 out of 5 years?
Yes, I believe that's the rule.
So if it's only 1 out of 5,
It doesn't qualify.
it doesn't qualify.
Right.
It's still your personal property.
Correct. Correct. And technically, a personal residence, there's a holding period of 2 years. So if you buy a new residence and you sell that previous residence within 2 years, you can still claim the exemption on it. So that's where that 2 years comes in. You don't need to roll after, because you can, if you've used the same amount of money or the money in the new replacement, you still get to take on your tax return, you get to claim your exemption, your personal residence exemption. But after 2 years, that goes away. So then it becomes, a possibility to use it for 1031. All right. Biden's proposed limitations. All right. So in the Green Act, or whatever it's called, the proposal is that they will be limiting the 1031 to 500,000 for one spouse and $1 million for a couple. And that's a significant down limitation, because right now it's open. I mean, you can defer 400,000, 800,000, and that would no longer be the case under the changes. The stepped up basis I've already talked about with the death and how that affects. Local real estate exemptions, I'm going to come back to the limitations in a minute, but the local real estate exemptions I want you to be aware of. Obviously, y'all know about homestead exemption, that people, and you tell your customers, make sure that you apply and get your benefit of that. There's widows exemptions, there's veterans exemptions, there are other exemptions, there's agricultural exemptions. You want to make sure you don't have to know them all yourself, although you can go to the website and learn about them. But you want to be able to make sure that your seller or your buyer is getting the best exemptions. So I've can't tell you how many times I have sellers that own properties adjacent to the, they own the lot next door, and they haven't combined them for the purpose of the homestead. Or, and I mean, these are clients that I'm maybe consulting with for estate planning, and I'll say, why have you not combined those? I don't know, it's just the way we bought it. So, that's something you look at the properties. If they own adjacent properties, they can combine those with the property appraiser's office, get one tax bill, and have the exemption applied to all of it. So there are different things there that you can help, if you're aware of it, as an informed agent, you can share that information, not legal advice, but just make sure that they're aware that there are other exemptions, and they can seek counsel, or they can go to the website themselves and get those details. You don't want them to miss out. The city code demolition issue is something that recently happened to one of my clients. He was buying properties from an estate, and he knew that there was a city code on it. In fact, we were paying the city code. We'd gotten a settlement, and we're paying that at the time of the closing. He hadn't gone to the property in 3 months. By the time he went to the property a month and a half after closing, the house was gone. It was in bad condition because of Michael, and he knew that, but he didn't get the notices. They went to the personal representative of the estate, and they didn't mention it. So you have to be really careful. When I'm, he happened to be an attorney himself, so he should have known. But it was something where I didn't know the condition of the property. As realtors, you're more apt to know the condition of the property because you're looking at it with your client. You may be telling, but you want to be careful if there is a property that's in that poor shape. You want to just be aware that that can happen, that it can get demolished, pretty quickly from the city. What I always do when I'm working with one of those is I notify the city officer. I say, we're in the process of a deal on this. Please hold off any action and let me know if you're about to take any action. And they do that. Okay. Capital gains on the sale of vacation secondary property. Again, this applies, for you to be aware of for your customers. If they have a secondary home, that home, they're not going to have the personal residence exemption, so they're going to have a capital gain issue. So they may want to look at rolling that with a 1031 deferral. If they're going to reinvest it in another property, that's the way to handle it. And that brings us back to Biden's proposed limitations. Those limitations are likely to come into effect if the law passes in 2022. So you may discover that in the next 4 months that we have left of 5 months that we have left of this year, there's going to be a stir of 1031s because they can still take maximum advantage. But what we're warning people is that you want to have it completed. They want to complete that replacement purchase in 2021. Because if it carries over to 2022, we're not quite sure how it's going to be handled. It could get stuck with the limitations. Okay? So those are what I prepared for you. Any questions? Any other questions? Yes?
If this buyer is buying 2 properties and selling an investment property, can one of those properties be his primary residence? He's selling an investment property, he's buying a rental and a property for himself. Can they
No,
both
that
be-
would not qualify as like-kind.
Okay.
To qualify, the replacement property also has to be investment property. Now, he could hold it, he could buy a property and 2 years later turn it into his personal home.
Okay.
But for 2 years, he has to hold it as investment property.
Can
Yes.
you go into the limitations? I know, isn't it like less than, you can't occupy the home more than 14 days? If you're buying it for a 1031 exchange, it has to be, you can't occupy it for more than 14 days. And then like you have to rent it to someone for fair market value for at least 14 days.
I'm not sure of the specific rules on that without looking it up, but And unfortunately, my master materials for 1031 are in a pod waiting to come back to
Sure.
my
Here.
office. But I didn't get that detailed. But yes,
Okay.
there's a restriction. You can live in the property for a time, but it has to be limited, it has to be controlled, because you do have to have that investment purpose. So you have to have a more on the investment side, the rental
And the
use.
reason why I ask is the person that I have now who wants to do a 1031 exchange, they were wanting to move into it to fix it up. And so they were worried about, what the limitations would be. Could they temporarily occupy it to fix it up, but then it's going to be a rental, and what the time limits on that would be?
I could look that up, but
Okay.
I don't know that it's limited to 14 days. That's
Okay.
what threw me when you said 14 days. There is a,
Okay.
But there is a time frame.
That's what YouTube said yesterday, so they could be wrong.
Well, it might have, if it was an accountant or an attorney, it might be
Yeah,
right,
no,
but
no.
I'd be cautious of that because.
Yeah, I was just trying to
Yeah.
get some information, so I was like pulling all sources.
Yeah, you are able to use it, and that, I guess they're not really living in it as a permanent residence,
Yes.
although they might be if that's their only place to live for that limited time period.
Yeah,
But they're turning it into investment. Yeah, I'd have to look up and see if
Okay.
there's really a specific time
okay.
frame on that.
I'll give them your card.
Yeah, sure.
I want to say it's like 14 days to enjoy it, but then you can have maintenance days,
Okay.
I think, because we owned condos at one time. I
Okay.
think that's what it was, to have it as an investment property.
Okay.
Really not anything to do with it.
Yeah, and I like who's checking in on it. Or I just
So
didn't
they
want
can
anybody
always
to like.
tell you
Okay.
that.
Yeah, is it,
Perfect. Thank you.
and are you saying it's 14 days out of a year?
14 days out of the year to enjoy it, but then you can always call the other days maintenance days.
Okay.
Or, so, and that, now that was 3 years ago, so.
Okay.
Yeah, I'm not aware that that's
Maintenance day.
changed.
Yes.
My sister's an accountant, so.
And I myself will tell customers, when you start getting into detailed things, when you start
Sure.
getting into your capital gains, I don't know your tax situation. I don't know what rate you're going to be taxed at. That's a discussion for an accountant.
Okay.
Yeah. Yes.
Is this, the 500,000, is that already gonna go into effect for 2022, or we don't know?
It has not been passed yet.
Okay, and then, so what would happen is, say my seller
Mhm.
was going to sell their condo for $550 and buy another one for $550, which you're saying that the $50,000 they have to pay tax on, is that how that works?
Yes,
Okay.
yes. They can only defer the 500,000. If that goes into effect, and it would be for next year. Yeah, wouldn't come into effect this year. I shouldn't say that because they can make it retroactive, but I can't imagine any legislative making it retroactive. So you never know what goes on anymore.
So the initial start of a 1031, let's say they have a residential property, residential condo, they're gonna sell that and move into something that they rent. They're gonna take the money from the original residence and turn it into an investment property.
Not a residence. If it's their residence, it doesn't qualify.
Okay.
If they were renting a condo, if they had a condo that they were renting out all the time, that's an investment property. But your personal residence, that's why you got to be careful when you say home or residence, that doesn't qualify as investment property. Now, that doesn't mean that a house that is a residence couldn't qualify. If you're renting out a house, that's an investment. But you have to rent it. You can't be living there. Yes?
Oh, sorry, it's here, man. So with your question, I kind of dealt with a similar situation, and it was, or at least what we were informed was you had the 180 days to make those improvements on the house.
Okay.
So when you've got the 180 days to close, it's kind of sticky, but it has to be within those 180 days to rehab the replacement or the outlet.
Okay.
Is that before you close? Right, right. So you enter your contract and you go ahead and you have it locked in and do your repairs before you actually close.
Yeah. Because finding a seller that's really gonna want you to do that's probably hard.
Right. Yeah. Unless they're, you know, if they're not living there, they may, but they obviously will want to close sooner than later. So
Sure.
you might have to put some substantial monies up front, you know, a deposit, non-refundable deposit. There's a way to, you know, to try and make it attractive so you can both accomplish what you want to accomplish. Is that? Okay. All right. How are we doing on time? 12:30. So we're good on time. I didn't know how long it would take. And Kim can tell you, I try to move things along pretty quickly. Let me see if I have any other tidbits I can share. I heard somebody mention earlier about the contracts, and I do teach that course usually about once a year. It's, you know, one of the things that I will say, oh, I do have something else on my list that I can share. I think it's really, really important as realtors, and being in my business for so many years as an attorney and as a title person. What makes a really good realtor stand out is their attention to detail, their professionalism. Preparing the contract, knowing how to prepare the contract, filling out the little blanks. I mean, it tells you on that contract that there's a blank on this line, please pay attention. Fill it out, mark it off. People don't. You know, if there's going to be a division of costs that's different than what's in the contract, put it on the special clauses or attach a page where, you know, you say who's paying what costs. Be clear. There are times when you want special clauses put in and you need to be careful because certain things, and you go to your broker first because they can sometimes help you with language, but other times it's beyond the language that you should be providing. And then you just call up an attorney, you know, that you've worked with before. For the most times, you know, my realtor friends will call and say, can you help me with this language? I help them with the language. You know, it's very rare that I will ever charge them a fee. They'll bring me a lunch sometimes, or my office a lunch. But basically it's a situation where, you know, they need an attorney to give them that language. So be careful of that. But I see this all the time with contracts where we, you know, the realtors don't attach, for example, on a VA or an FHA, you need that rider. And that rider says that the seller is going to pay certain costs. And if you haven't warned the seller of that, all of a sudden the seller is upset. And I've had one recently where the seller was a realtor and they got upset because the VA rider said they had to pay certain costs. And they just didn't know it. So, you know, it's really important for you, you know, if you haven't taken those classes, take those classes, and then, you know, every once in a while refresh for yourself so that you know those things. And the other thing that I had to share was the key issues of what makes a good real estate agent. Anybody want to guess what some of them are?
Communication.
Communication would be a really big one. I think that's a really big one. Anybody else? Timeliness. And that raises another issue on contracts. Contracts have certain time frames. Your inspection, your title work, they have time frames. And for the most part, you know, they just go on by and it's fine and there's never a problem. But there are those occasions when it becomes a problem. Inspections, you guys are pretty good about. Realtors know what the time frame is, you know, 15 days or whatever it might be for the inspection time period. They make sure it's done. They make sure it's, you know, provided to the, you know, other parties, to the seller, you know, if there's an issue. Title work is not so carefully followed. You know, I try to make my office aware of it. So, you know, we set a deadline. This is when you have to have that title work to them. Because that can become an issue if later there's problems and one party wants to get out, they're going to turn around and point the finger at, well, I didn't have the title work in time. So then it becomes, you know, whoever was responsible to provide that title work, it becomes part of their problem and it becomes part of the title company problem. So, those things, timeliness is a big issue that you guys need to be prepared and know your contracts well enough to know that you have timeframes to live up to. So, here's what one of the places online indicated. Trustworthiness. Okay. And part of that, I think, is, well, I don't know because I wasn't part of that, this survey, so let me just tell you what it is. Trustworthiness is the top quality sellers say is important in an agent. It's extremely or very important to 86% of sellers. A trustworthy agent won't try to persuade you to work with them by giving you an unattainable listing price. They always get reasonable expectations, outline their responsibilities, and give you time to review the listing agreement before deciding to work with them. Okay? That I think is important. The attainable listing price, of course, in today's market, how many of you have seen a listing price and you get into a bidding war above that listing price? That's a nice thing that's happened, but it may not always be there. Sincerity is the second one. Great agents are always honest, even if it means saying things you don't want to hear, like your home isn't worth what you think it is, or that it needs improvement. They build a relationship with you based on honesty and keeping your best interests at heart. I've had situations, I've been involved in some complaints against realtors, some bar complaint, or no, it's for us, it's bar, for you, it's DPAR or the realtor complaints, and ethics. And we had a situation once where a realtor had a listing. The inspection determined that there were foundation problems with the property. Pretty major repairs were needed. So the seller pulled the listing from that realtor, took it to another realtor. It so happened that that realtor, may not have been aware of the problem, wasn't told by the seller of the problem, but a realtor for the buyer knew of the problem, and they made them aware of it and said, now that you know of it, you have to put it in the listing. You have to put it on the MLS, or you have to at least disclose it when you're dealing with people. And that's what happened. They didn't want to disclose it. They didn't want to know about it. They said, I don't know about this. Well, yeah, now that you know, you have an obligation to tell people. So that sort of thing. Top agents put their sellers' needs above their commission. That means they will go above and beyond to move a deal forward, whether they're physically pitching in to help you get your home staged or buying a new light fixture the buyer wanted. Another, a couple stories come to mind on this because we recently had a realtor who was just so difficult to work with for her customer. But the customer loved her because on the sale of his property, she had staged the house for them. They had done she had done lots of good things, got it sold. But on the buy end, it was just such a difficult process. She questioned the mortgage. She basically wanted to read the documents herself before the time. It was just a strange, bizarre situation. But, in that instance, she did work for the seller, and the seller was thrilled. And so when he became a buyer, he used her again, and, it just worked out for him. It just didn't work out so well for everybody else in the transaction, but that's okay. Other times, commissions. You guys do your work, you're entitled to your commission. Too often, I've seen some of the agents that will, say, okay, something comes up, I'm going to give you part of my commission for the closing. That's fine, but protect yourself. I've had to file lawsuits to get, where there was a note, everything was done properly. The note was signed, a mortgage was signed to protect the realtor commission, but instead of returning the note to the title company so it could be recorded, they kept it, the mortgage. So it was never recorded. So now the realtor, the buyer that took advantage of that situation is getting ready to sell the property, and we had to rush, get a lien filed so that we could get the money out of the sale of the property. So, you know, you guys can be good guys and help out, but you want to protect yourselves when you do. Another thing that experienced attorneys and title companies occasionally will do, you know, we've seen this, and I've had to do it, you know, when at a closing table. Now, we very rarely anymore have a closing table where both buyer and seller are present. How many of you feel?
Very.
Yeah. In my day, we always did it that way until I came up here, and then we discovered that they always had them separate. So, and of course, as CFPB came along, then it was more dictated by the laws that you had it separate. But when it starts to get iffy about, you know, last minute repairs or, you know, items, you know, that come up, there are times when the realtor or the closing agent, the attorney will say to the realtor, I want you to step out. And you might say, well, why are they doing that? And sometimes it's because we are trying to protect you so that that person doesn't say, well, you chip in $150 on this, or you chip in $500 of your commission towards this. If you're out of the room, they can't do that to you. So be aware sometimes when an attorney or a title closer asks you to step out, it may be protecting you. It's not necessarily trying to take advantage of the client, but it's, you know, a two-way process there that they may be trying to just protect your interests. Okay, another item on there is real estate is not a 9-to-5 job, and a great agent understands and embraces this. They don't resent clients for reaching out to them outside of traditional working hours, and they won't take off for a vacation without telling you. Well, I don't know about, I mean, I know you guys get called on Saturdays and Sundays and all sorts of times. I don't give my personal phone number out for that reason. I don't want clients calling me at all sorts of times. So, you know, I feel for you because I know you guys work extra special hours when you're a realtor. And good agents know that sometimes plans change and not every deal works out. They'll understand if you decide to take your home off the market, and they won't hold you to the commission agreement if you have a change of heart. There are times when that's appropriate and other times when it's not. You know, I'm sure if you have not yet been in one of those circumstances during your career, you will get in one of those circumstances. So, you know, it's a call, and it's a call that sometimes your broker is going to end up making as opposed to you. But I rarely see any more brokers that will sue for a commission. It's just very, very rare. Even when it's a forfeited commission going to the seller, I very rarely see the realtor or the broker ask for their part of that commission. It's happened. I've sued, you know, in the past years and years ago. We had some lawsuits on it, but you know, I rarely see it up here. In South Florida, it's more likely to happen. All right, that's my presentation. Hope you guys enjoyed it. Hope you learned something.